SJC 13011 in the matter of an impounded case.
Okay. Mr. Brioni, quick. Leone,
Good morning.
quick, sorry.
No problem, Chief Justice. Good morning, everyone. My name is Brett Leone Quick, and I represent the appellant in this appeal. I'm going to focus my presentation this morning on why the probate court misapplied the second stage of the augmented Duracraft framework that this court has established for deciding motions to dismiss brought under the Massachusetts anti-SLAPP statute. I'm also going to address why the probate court doesn't have jurisdiction over any of the claims that are before it, and why it erred as a matter of law in refusing to give full faith and credit to a judgment entered in Minnesota. Now, both parties agree that this appeal involves claims from regarding distributions from a Minnesota trust that are governed by Minnesota
Mr. Brioni,
law.
quick, before you, I think we have a big interest in whether the anti-SLAPP statute is at all applicable here. Before I wouldn't jump into these other issues before you give us comfort that the anti-SLAPP can be applied to this kind of accounting procedure, because we're far removed from sort of where anti-SLAPP started at this point. So could you start particularly with the argument that this accounting procedure is just not a civil claim that's covered by the anti-SLAPP laws? Because I wouldn't skip that step if I were you.
Sure, I won't skip that at all. I'll address it right now up front. So I think you can start with the plain language of the statute, which makes the anti-SLAPP statute available in, quote, any case where a party asserts, quote, civil claims.
Is this a civil claim?
This is a civil claim, I think, and here's why. You read the amended objections, it makes allegations of fact, and it alleges a legal theory under which the appellee seeks damages. If that doesn't fit the definition of a claim, however that term is defined, I'm not sure what would.
So every account, what is, again, we're not probate lawyers, so walk us through a little bit. This is an accounting process. What's it called, and what is its purpose?
Sure. So conservators annually file accounts with the probate court, and I think a good way to get acclimated to what this looks like is page 28 of the record is the account forms that the probate court require that conservators use. That'll give you a good sense of what these accounts look like, because I think that informs what an objection to account will look like. And so when you look at the form that's mandated by the probate court to use for filing accounts, you'll see it has three schedules. There's Schedule A, that lists the receipts or the income that have been received from the trust during that year. Schedule B is the expenses paid by the estate or debts owed by the estate. And then Schedule C is kind of a summation of the assets on hand. And so when a conservator files an account, and if a protected person wants to object to the account, then the objection needs to focus on things that are listed on the account or things that should have been listed on the account. For example, if there is an estate asset that isn't listed on the account but should be listed on the account, that's a proper form of an objection. And if, for example, there's an expense listed on the account that is excessive or inappropriate, that's the sort of thing that can be objected to as well.
Is this like, I mean, again, I'm using lay terminology and I apologize, but is this also like a final accounting? Is there a finality purpose to these objections where we're basically going to get all this done and move on type of thing?
That's right. So the process plays out in that fashion where the conservator can move for a final settlement of all of the accounts at the end of the conservatorship. And at that point in time, the probate court has two options. One, if there's an objection to the account, it can hold a proceeding where the objections are resolved. Again, that gets back to my initial point, why this is like a claim, why this is like a case. The regular rules of civil procedure govern situations where there's an objected to accounting. So an objected to accounting is a proceeding almost identical to any other piece of litigation that you would see in the superior court. In fact, it's governed by the same rules of procedure. So an objection to an account, while focusing on what's identified in the account, does take the form of litigation. It's an action where allegations have been made that something is not appropriately reflected on the account, or is, like I said, it's an excessive expense. And then that issue is litigated in the manner that any other claim or case would be litigated.
And Mr. Brioni, quick, are there other cases involving accounting where, are you aware of any other anti-SLAPP cases brought in the context of accounting? Because accounting is a fairly common corporate procedure too, right? I mean, has anti-SLAPP ever been brought into one of those that you know of?
We have not seen any published decisions on that. I think our papers have reference to one appeals court decision that's unpublished, the Pothier versus Pothier, if I've pronounced that right, case. And that dealt with a proceeding in the probate court, which did not, the court there apparently wasn't troubled by the fact that the anti-SLAPP statute was being applied in the probate court case. But we haven't seen any reported decisions involving objections. I think that's a function of two things, though. One is it just means that they haven't arisen in enough numbers to filter up through the system and become published decisions. Two, I think it's a function of what we were talking about before, which is the purpose of the account is not to allege wide-ranging claims, wide-ranging conspiracies like the amended objections do here, but they're really intended to focus on specific entries in the account. And yes, in that context, in a proper accounting context, the anti-SLAPP really wouldn't apply, because those types of issues that the accounting process is intended to focus on wouldn't necessarily give rise to the types of allegations and claims that are subject to the anti-SLAPP statute. But that's not the case we have here. Here we have an amended objection that goes far beyond anything that's in an actual account. In fact, there's really no nexus between the allegations and the claims asserted and the accounts that were actually filed. And so I think the anti-SLAPP statute should apply. And I guess another way of looking at it is, why should we be drawing a bright line here that exempts entire types of cases or proceedings from the reach of the anti-SLAPP statute? There's nothing in the plain language of the statute that suggests we should do that. There's nothing in the legislative history I saw suggesting we should do that.
Can I ask you to go on with that explanation? Is there anything about anti-SLAPP and its purposes that would lead to its proper application in an objection to an accounting?
I think it does, because again, the purpose of the statute is pretty broad. It's to protect lawful petitioning activity across a very broad spectrum of instances. And so I think applying it in the probate court context doesn't raise any issues at all. There's been a suggestion in the appellee's papers that this would somehow usurp the jurisdiction of the probate court to oversee conservatorships. And I just don't see that, frankly. This will simply weed out claims that the legislature has said do not belong in any courts of the Commonwealth. Certainly if these claims were asserted in the Superior Court, the anti-SLAPP statute would apply. And so it's unclear why it shouldn't apply, just because it's been these same sorts of claims that would be subject to the statute in the Superior Court. The statute somehow doesn't apply because the same sort of allegations and claims have been made in the probate court in connection with an accounting process. So, I don't think it'll, to kind of finish my point on this, I don't think it'll interfere with the probate court's jurisdiction over conservatorships at all. It'll simply allow conservators to enjoy the same protections that anyone else has under the statute when they're engaged in lawful petitioning activities. it won't weed out legitimate claims against conservators. Those will stay. That's what the augmented Duracraft framework is intended to do, is to differentiate between claims that should go forward and claims that should not. So
I'm going to encourage you, Mr. Leone Quick, to move on to your actual argument with regard to the SLAPP statute, only because your time's running out.
my time is running out. So thank you very much. What I want to focus on again is the second prong of the Duracraft analysis. And under that prong, it's the appellee who has to carry the burden to show both, one, that the claims are colorable, and two, that the claims were not retaliatory. And it's on this prong that the probate court erred as a matter of law. This court held in Blanchard too that colorability in this context means whether the claim, quote, offers some reasonable possibility of a decision in the party's favor. And there are numerous independent reasons why the claims for attorney's fees are not colorable here under this standard. The first one is because my clients did not owe any fiduciary duty as conservators at the point in time when they petitioned the Minnesota court to reform a family trust. The timeline goes like this, very briefly. In October 2014, the probate court terminated the guardianship here and transferred the question of whether the conservatorship should continue to a Florida state court. In July of 2016, after a trial, the Florida state court sided with my clients and determined that a professional trustee should be appointed to oversee the corpus of this estate. In July of 2016, pursuant to that order, my clients transferred custody of the entire conservatorship estate and all of its assets to the professional trustee, and they were only required to file accounts through July of 2016. The probate court's decision below specifically recognized that July 6, 2016 was, quote, when the conservator's role of fiduciary was effectively terminated by the Florida court's order appointing Northern Trust Company as limited guardian of the protected person's estate. In addition, in January of 2017, the parties stipulated to the end of the conservatorship in Massachusetts. It wasn't until August of 2017, a year after my clients stopped being conservators over the conservatorship estate and its assets, that they filed their petition in Minnesota. So
but don't we have, and again, I thought the probate court judge's decision was, sort of very perceptive. And it talks about the fact that for 15 years, your clients didn't do the accounting, right? Or, basically something that should have been happening on a regular basis wasn't happening at all. And this was part of sort of an orchestrated, campaign. I'm not sure, again, I don't know the truth of that, but it's disputed. And it looks like that's what was driving the probate judge to reach the result he did. And there seems to be, particularly, he's an expert in this type of, trust issue. Don't we wade into this carefully, right?
Well, I think, sure. And I think, though, what we're really focusing on with colorability, can be reviewed by this court. And the probate court's decision on colorability really isn't based on any kind of specialty knowledge or specialty rule with respect to the probate court. Again, it goes to breach of fiduciary duty, which I've just talked about, which indisputably, and even pursuant to the probate court's own decision, didn't exist for my clients at the time they brought their petition to me.
But the problem is, at least according to my reading of the probate judge's decision, for 15 years, your clients don't live up to its fiduciary obligation, at least in this accounting aspect of this.
And Your Honor,
And then the lawsuit immediately takes them out of the whole equation. They're no longer conservators. It also fixes some obvious problems with the trust, but I think the judge is saying, I got to reserve judgment here, whether this is retaliatory or without merit, because there's a lot going on here, and your clients are fiduciaries to this, at one point, mentally ill, protected person.
Sure. So the way I would address that is the original objections that have been completely resolved and are not before the court anymore, the probate court or part of this appeal, dealt with that fact that the objections had not been filed for 15 years. There was motion practice. There were claims made based in part on the delay in time, and those have been resolved through a settlement of the parties. These are now new issues in different issues, and I really don't think the issues bleed over. My clients paid a price in settlement with respect to their tardy filing of accounts earlier, and there's really no connection between the claims at issue now, the amended objections at issue now, and the fact that the accounts had not been filed for several years.
Leone, quick, you mentioned legislative history. Isn't part of the legislative history, and we see this mentioned in a lot of anti-SLAPP cases, that the whole point of anti-SLAPP was you had folks out there who would engage in petitioning activity, and they just get overwhelmed, crushed, and intimidated out of litigation. And that oftentimes we see anti-SLAPP in the antithesis of that situation. And even when used appropriately, it becomes not that, but a litigation weapon. Isn't that part of the legislative history?
That's part of the legislative history, and that's what I wanted to address as well in terms of the kind of the judge's finding, the probate court judge's finding on retaliatory purpose and retaliation. And he based that on two factors. One, which we say is not appropriate, which is that the claims were only filed after the petitioning activity occurred. And then two, that this isn't the typical case, that this isn't the case of a developer against a citizen of modest means petitioning the government. And that isn't a dispositive factor either. And this court has made it clear that while that describes the typical case, the legislature intended to go beyond the typical case, and there can still be retaliation even when that's not the issue. And here we have some hallmarks of retaliation. We have a bitter intra-family dispute that's gone on for years and years across 3 different states. My client is 80 years old, over 80 years old, and she's in fragile health. She specifically withdrew from the Minnesota litigation because, quote, her desire to withdraw from this difficult family litigation and eliminate a number of contentious issues from this case. She paid a significant sum to her son to settle the original objections to the account to avoid having to go to trial against her mentally ill son up here in Massachusetts. And so I think these are precisely the types of factors that this court has said are part of the totality test that should be considered when dealing with retaliatory claims. I'll wrap up. I know and I'm happy to entertain more questions, but to the extent there aren't questions, I'll wrap up quickly here. And I'd like to end kind of on a practical note. I think the cleanest way here to reverse the probate court's decision is to find that it erred as a matter of law in finding colorability of the claims. And I addressed it briefly, and it's laid out in our papers. I think the probate court committed clear error in this regard, and reversing on that basis would represent a pretty straightforward application of the augmented Duracraft framework, and it wouldn't otherwise disrupt or change the existing landscape with respect to the anti-SLAPP statute. In addition, dismissal of the claims on the basis of lack of subject matter jurisdiction will advance the important objectives of judicial economy, and it will provide important guidance to the probate court and litigants
Doesn't that
concerning
mean
the
that
scope of the probate court's jurisdiction.
if we mean that whenever an anti-SLAPP case is brought, all this other stuff, particularly this is a narrow anti-SLAPP, right? It's only one part of the accounting is challenged, right?
That's right.
So we've got this little anti-SLAPP issue on one part of it, and now you want us to accelerate a decision on all these other issues that aren't even related to the anti-SLAPP that would ordinarily wait a whole trial. Why would we do that? Aren't we then just inviting everybody who wants to skip the whole process to file anti-SLAPP cases? Because it's going to basically jump the whole thing forward into the appellate process.
Yeah, I mean, I think that risk, sure, I can't say that that risk doesn't exist. My sense is, though, that that risk is minimal, just because this court does have the discretion, for example, on subject matter jurisdiction. It does have the discretion on whether it wants to take that question up or not. It decided to do that in the Maxwell case, admittedly, reluctantly, but in this case, we think this is the same type of extraordinary circumstance that existed in Maxwell that would warrant raising and assessing the subject matter jurisdiction issue. The issue is fully briefed below and before this court. Discovery has been completed, and so there's no more facts that need to be discovered. And even the probate court's decision on its motion to dismiss recognized that this theory, the claims here, the differential distribution claims theory, he called it a novel legal theory, and admitted that it, essentially that it was unclear to him whether those claims should move forward or not, but ultimately decided to let them go forward. And so there's that factor here, that judicial economy, when there's an important issue that we know the lower court, at least in this instance and possibly in other instances, is struggling with, it makes sense to address it now.
It's struggling with the fact that whether it's an accounting issue or whether it's, in your case, a tortious interference one, isn't that going to be, you got to really understand all the underlying trust documents and what the fight is about here to be able to answer that question. It doesn't seem so, it's not a straightforward issue of law, is it?
In some ways, I recognize it's complicated. It doesn't seem that way to me because I've been living this, for a long time in this case. But here's maybe the best way to decomplicate it, and that is, these were discretionary trusts. The protected person here wasn't entitled to any distributions from them, but has alleged that the conservators took steps to somehow interfere with the discretionary distributions he would have otherwise received, but for that interference. And that's the heart of those claims. And so in some ways, it's very simple. That's a tortious interference with an expectancy interest type of claim. A Superior Court recognized that in a very well-reasoned decision, Hannah v. Williams, which we cite in our papers. That sounds in tort. That doesn't relate to conservatorship property. It relates to a contingent or expectancy interest. And the Commonwealth, yes, has recognized a tort claim with respect to that type of fact pattern. And so that's where this case fits, and that's where this case should really live.
Okay.
Now, finally, sorry.
Yeah.
I do just want to make clear for the record that the conservator will be seeking her appellate fees under the anti-SLAPP statute should she prevail on this issue in this appeal. And if the court wishes, the conservator will submit a letter to memorialize this request pursuant to Rule 22C.
Is that request in the record?
That's why I'm making it here on the record. And like I said,
this is the record.
This is the
Not
record.
your brief. Okay.
Not the brief, but to the extent that this court wants it in the written record, I can submit a letter after this argument under Rule 22C2 to make it formal.
Yeah, you might want to do that.
Thank you. We will do that. Thank you. Thank you for your time.
Okay. Attorney Waters.
Good morning. Thank you. And good morning, Chief Justice Budd. Good morning, Justices of the Court. My name is Charles Waters. I represent the appellee, William C. Hamm. Mr. Hamm was the protected person for 16 years in a guardianship, and his parents were the guardians over his person and assets for most of those years. Later on, they became only the conservators over his assets. Now, despite the sizable estate and all the attorneys advising the conservators, they didn't file an inventory at the beginning of this case. They didn't file a single accounting for 16 years. That's the basis of this objection. The protected person is now 51. He's happily married, and the court has since ordered restoration of his full capacity. But he objects to this accounting because to the extent that he is attempting to learn what the actual assets were for the 16 years while the fiduciaries had exclusive control of them. Now, we're here today in this court because the conservator is making an unprecedented attempt to strike portions of the protected person's objection to their account by using the Massachusetts anti-SLAPP statute. This has never happened before. The statute's never been used like this in accounting, not just in Massachusetts, but anywhere I can find. And my client asked respectfully that this court issue a simple decision, making sure that this type of weaponization of the anti-SLAPP statute doesn't happen again. Put simply, the statute.
They're only attacking they're attacking the request for the accounting based on the Minnesota lawsuit, right? It's a narrow one, right? They're not trying to question your ability to count all of it. It's just that part of it, right? Under anti-SLAPP.
That's correct.
And there's precedent for that there's precedent for, if you've got a multi-part thing and only claim, and part of it is based on a piece of litigation, that you could target that part for an anti-SLAPP, right?
Well, in a civil case, yes,
right.
But this isn't a civil case, and it's never been done in an accounting case.
And so then that gets to the big issue. So your brother says, look, the rules of civil procedure cover this type of accounting. It's a traditional litigation in just another form. So why wouldn't we treat this as a civil case or a case?
For a number of reasons, but there are remarkable differences between a typical civil action and an objection to a fiduciary accounting. You can start with the language of the statute itself. It does not encompass objections to fiduciary accounts. It instead speaks in the language of typical civil litigation. The special motion may be filed in response to, quote, civil claims, counterclaims, or cross claims. That closely tracks Rules of Civil Procedure, Rule 7A. It also says, quote, that they can file the motion, quote, within 60 days of service of the complaint. The complaint is, again, language that tracks Rule 7A. Now, procedurally, that makes a difference. A typical civil action is filed through 7A, plaintiff files it, and the case begins. But that's not how it goes for an objection to a fiduciary accounting. Instead, you look at completely different statutes. You look at General Laws, Chapter 190B, Section 1-401 and 5-418, as well as the Probate Court Rule 72. Now, this requires a multi-step process, not just a one-step plaintiff files complaint and you're off and running. This requires a multi-step process that includes the filing of an accounting, the issuance of a service of all interested parties, and then the filing of a written affidavit of objection. Obviously far different than the typical civil action case. Now, the different procedures occurs because the parties in a guardianship have different relationships with themselves and with the courts than civil actions do. So an objection can only occur in the context of an existing action in the probate court in which the court has already appointed a fiduciary. And again, that's not like a typical civil action case. And that fiduciary.
So can I just, Mr. Waters, can I just pin you down for a second? So that means your only objection is to anti-SLAPP. It's not in probate court altogether. It's just in this accounting process, because we've got a lot of frivolous litigation in probate court where people sue and cross sue and, they sue for suing. But you're not saying that you're not asking for a ruling that anti-SLAPP doesn't apply in all probate proceedings, just in this kind of accounting proceeding. I'm just trying to clarify what you're.
Yeah, that's correct, Your Honor. And my brother counsel mentioned that there was one, I think, unpublished decision.
Padia versus Padia. Mm-hmm.
Yeah, that was not an accounting case. So I'm only talking about accounting cases. And that makes a difference, Your Honor. That makes a difference because in an accounting case, there's an existing fiduciary who's already agreed to voluntarily have duties both to the court and to the protected person to do what's in the protected person's best interest. So it's an existing fiduciary with those obligations both to the court and to the protected person. Now, in these accounting cases, it's the court's obligation to oversee the estate and the fiduciary's actions. So the fiduciary reports to the court, and the fiduciary also reports to the protected person. And again, that's not like in a typical the civil action or any other case in probate court. Now, as a result, the accounting itself constitutes the fiduciary's efforts to comply with her fiduciary obligations to the court and to the protected person. So the accounting itself is the effort to comply with her existing fiduciary obligations. Nothing like that exists in typical civil action cases. Now, the differences in these relationships compels different burdens of proof in accounting cases than in typical civil action cases. Now, you're all aware that traditionally parties asserting the claim has the burden of proof in civil action cases. But that's not the same with these objections to fiduciary accounting cases. After the objection, the fiduciary has the burden to establish that the account is correct. She also has the burden to establish that she complied with her fiduciary obligations in managing the assets and that there was no reason for the court to surcharge the estate. So there is no obligation that the protected person has after finally the objection, and the burden of proof is entirely on the fiduciary. Now, this is where anti-SLAPP comes in. If the anti-SLAPP statute applied to objections to fiduciary accountings, it would fundamentally change this statutory scheme. And instead of holding hearings in which the fiduciary has the burden to justify her actions, the court would instead be holding hearings to determine whether the objector, now with a burden under anti-SLAPP, has satisfied that burden under the augmented Duracraft framework. And if the objector doesn't carry the burden, then the court never considers whether the fiduciary has carried the burden to establish that she managed the estate in the best interest of the law.
But counsel, isn't that how it's supposed to work in an anti-SLAPP case? Why should it not be applied in a probate situation if it's supported by the facts?
Because I think it changes these burdens and it changes the statutory scheme to implement these burdens. And for example, if like here, the fiduciary, the conservators, breached their duties that culminated in a lawsuit against the protected person, that conservator would actually avoid any review of that conduct because that conduct led to this lawsuit. The lawsuit would be considered petitioning activity. And so the objector, if you follow this argument, and I don't agree with it, but if you follow it, the objector ultimately wouldn't be able to pursue his objection because it would be knocked out by an anti-SLAPP special motion. That cannot be what the legislature had in mind. And we provided the court in our papers the legislative history, and you see that the legislative history, in fact, did not have that in mind. Our brief shows the bill, the HB 1520. We went through Governor Weld's veto of it, the floor debates, the House debates of the veto override, and the Senate debates. Mm-hmm. And all of the legislative history shows that there was concern about civil lawsuits against ordinary citizens. And these civil lawsuits bullied the ordinary citizens, and from which they needed protection. There isn't a single reference in any floor debate or any other piece of legislative history showing that they were remotely concerned about accounting proceedings in probate court. Now, with this in mind, the court should narrowly construe the anti-SLAPP statute to achieve the legislative aim that I've just mentioned without prejudicing the non-moving party. They've done this in the past, and we've walked through in our brief the Duracraft case, the Coburn versus Gaff's Friend case, the Global NAP Inc. case, Cato Company, and Blanchard, in which the appellate courts have all reined in the anti-SLAPP statute. They've narrowed it because the language of the statute is broad and would trample on constitutional rights if read without narrowing. So the lessons from the cases that the SJC and the appeals court in Massachusetts have issued is that the anti-SLAPP statute language applied broadly causes these constitutional problems. And they don't achieve legislative intent of eliminating the lawsuits filed primarily to chill the petitioning activities. And they encourage weaponization of the special motions. And with all due respect, I have a different perspective of weaponization of this particular case. I think this anti-SLAPP special motion was weaponization of the statute. It allowed the fiduciaries to put aside a trial that was imminent. We were there for a pre-trial hearing, and these motions delayed that trial and continue to delay that trial probably up to about 18 months. And it also allowed the fiduciary to bootstrap other appellate issues that have no interlocutory right of appeal. And in fact, that's what the fiduciary has done here also. So,
Mr. Waters, if we wrote this decision the way you want to, we would simply decide that the anti-SLAPP statute does not apply to the accounting procedures, and the rest of this belongs back in the probate court for resolution. Is that what you're asking us to do?
I think that's exactly right, Your Honor. And it
And
can
are
be as
you
narrow
asking
as
us
that.
to decide anything else besides that? If we reach the conclusion on the first issue, that's all we need to decide today. Is that correct?
From our perspective, that's all, Your Honor.
Mhm, okay.
And that's what we'd be looking for. There's another, I think, obviously.
And
my
if we
argument-
did that, by the way, so if we reached that conclusion, then a trial would, then the probate court would then try the accounting fight here. And all these issues would then percolate up in the ordinary course. Is that right?
That's exactly right, Your Honor.
Okay.
My client asked the court to issue a decision reflecting, Judge Kafka, what you just stated. To the extent that there's any analysis relating to the anti-SLAPP statute itself, I want to just identify one area that I think also should bring the court back to this notion that this statute is not applicable to these types of cases. And that's the first stage. Now, the first stage of the anti-SLAPP is when the moving party has the obligation to show that the claims are solely based upon petitioning activity.
Well, at least one of the one claim, the one part of the accounting claim seems to be based on the Minnesota litigation. I understand the judge in a very sort of thoughtful way took a 40,000, feet high perspective on all of what's happened for the past 16 years. And that may be the right thing to do, but you could see why litigating based on the Minnesota litigation starts sounding like an anti-SLAPP case, right?
Well, Your Honor, the allegations are actually start long before the Minnesota litigation. The allegation is that there was a pattern and a plan that dates back to 2012. So when these fiduciaries were still in their role as conservatives, they met with lawyers and they started a plan that was to keep the ward here, the protected person, as a quote unquote legally incapacitated person, because it would have beneficial impacts on these other trusts, that they could continue to influence the trustees to diminish the disbursements to the protected person throughout, that they would ultimately, throughout this time period, that they would ultimately insist that the trustees cut off the disbursements altogether. And then in the litigation, they attempted to actually change the corpus, who would receive the percentages of the corpus of the trust once the William H. Hamm passed away. So the culminating act was the filing of the lawsuit, which occurred after the fiduciaries were no longer servicing as fiduciaries. But the whole plan leading up to that, the 5 years leading up to that, is the fiduciary duty itself that culminated with the lawsuit.
Any other questions? Very good. Thank you very much, counsel. We'll take our morning break at this time.